किसी भी लिटिगेंट को ये कोई हक नहीं है कि वो यहाँ खड़ा होकर ये बोले कि ये जज कोई फैसला करने के लायक नहीं है, क्योंकि जज की कॉम्पिटेंस हो उसका हायर कोर्ट डिसाइड करता है, लिटिगेंट डिसाइड नहीं करता। जो स्टेटमेंट देश के होम मिनिस्टर ने कहीं पर की है, अखिल भारतीय अधिवक्ता परिषद के बहुत सारे प्रोग्राम्स क्योंकि मैंने अटेंड किए थे और वो श्री अरविंद केजरीवाल की आइडियोलॉजी के विरुद्ध हैं। ये कोई भी कैसे कह सकता है कि जस्ट बिकॉज मैंने किसी अधिवक्ता परिषद या लॉयर्स के फंक्शन में जाके मैंने एक लेक्चर डिलीवर किया तो मेरा माइंड इतना क्लोज हो गया होगा कि मैं दूसरे कई सारे केसेस को मैं फेयरली डिसाइड नहीं कर सकूंगी। ऑल द ऑर्डर्स दैट आई हैव पास्ड, यानी मैं जितने भी ऑर्डर करती हूँ इनके खिलाफ वो सारे ऑर्डर सुप्रीम कोर्ट उल्टे कर देती है। नाउ एप्रीहेंशन, द नेक्स्ट पॉइंट ऑफ श्री अरविंद केजरीवाल रिगार्डिंग जो स्टेटमेंट देश के होम मिनिस्टर ने कहीं पर की है। This court finds that neither this ground had been mentioned in the recusal application, nor any details were provided regarding the same. The accusation against this court is that there is a apprehension of bias in the mind of the litigant since the Home Minister of this country had made a statement in a television program. Seeking recusal of the court on such a ground that a union minister, or for that matter, any politician in a television program has expressed an opinion that a particular court may pass an order which may be adverse to a particular party would amount to proceeding purely on imaginations and disbeliefs of the litigant. Clearly, this court has no control over what a politician or the litigant himself, who is also a politician, may choose to state in the public domain or in his political life. It equally cannot regulate or control statements made by politicians in the public discourse. Even otherwise, it is a matter of common knowledge that such statements are made by political parties with rival in the public domain. The next ground, alleged apprehension of bias arising from participation of this program of this judge in some events organized by one अखिल भारतीय अधिवक्ता परिषद। अगला ग्राउंड था कि मैंने अखिल भारतीय अधिवक्ता परिषद के बहुत सारे प्रोग्राम्स क्योंकि मैंने अटेंड किए थे और वो श्री अरविंद केजरीवाल की आइडियोलॉजी के विरुद्ध हैं, तो इसलिए उनके माइंड में ये एप्रीहेंशन है कि मैं उनसे न्याय नहीं कर पाऊंगी। ऑफ ऑल द रिक्यूजल, लेकिन ये वाला ग्राउंड और किसी भी रिस्पोंडेंट ने नहीं लिया, ये सिर्फ अरविंद केजरीवाल जी ने लिया है। तो ये ऑब्जर्वेशन सिर्फ उनके एप्लीकेशन श्री अरविंद केजरीवाल जी के एप्लीकेशंस में बताई जा रही है। At the outset, this court must state that the functions or programs organized by Akhil Bharatiya Adhivakta Parishad were not political functions or party events. They were programs organized by a body of lawyers where occasions such as Women's Day celebrations, seminars for lawyers on new criminal laws, and other professional discussions were conducted, and speakers were invited to interact with members of the legal fraternity. The CBI has also placed on record, along with its reply and annexures, some flyers of the programs organized by Akhil Bharatiya Adhivakta Parishad. A bare perusal of the same would show that in the past, many judges of this country have been participating in them. In my opinion, merely because in my capacity as a judge, I was invited to deliver a lecture or interact with younger members of the bar or other members of the legal fraternity, the same cannot be used to insinuate political association. Such an argument has to give way to the right and duty of a judge to attend legal functions organized by members of the bar for the benefit of legal fraternity. It is difficult to understand what is meant by sympathizing with the lawyer's body without any specific allegation or material. Though it is understandable that membership of or active participation in the affairs of a foundation or body having direct affiliations or specific interests may in some situations raise an apprehension of bias, it is difficult to appreciate how, in the complete absence of such circumstances, mere participation as a chief guest or speaker in a legal program organized by an association can by itself give rise to an apprehension of bias or lead to a conclusion that such participation has foreclosed the judge's ability to approach the case with an open mind. ये कोई भी कैसे कह सकता है कि जस्ट बिकॉज मैंने किसी अधिवक्ता परिषद या लॉयर्स के फंक्शन में जाके मैंने एक लेक्चर डिलीवर किया तो मेरा माइंड इतना क्लोज हो गया होगा कि मैं दूसरे कई सारे केसेस को मैं फेयरली डिसाइड नहीं कर सकूंगी। It also does not escape the notice of this court The applicant, Shri Arvind Kejriwal, has selectively placed on record only those events attended by this court which were organized by Akhil Bharati Adhivakta Parishad. However, this court, as well as many other judges, routinely attend official functions organized by various universities, law schools, University of Delhi, NLU, private colleges, private and government hospitals, and different forums of lawyers. Even while serving as a district judge, I had visited several schools and colleges for delivering lectures as part of legal literacy programs. Needless to say, such educational institutions or forums may at times be headed by individuals who may have their own political ideologies. However, such participation is part of maintaining relationship between the bench and the bar and also engaging with the younger members of entering the profession or even at times the community in general. Whatever the organization may be, whosoever its founders or whichever college or university it may be, in any part of the country, judges are invited in their capacity as judges of a court to interact with law students or members of the bar. In such interaction, there is no space for any personal or political ideology, and the engagement is often confined to the law, the functioning of the courts, and the relationship between the bench and the bar. The relationship between the bar and the bench is not confined only to courtrooms, and it extends to various professional and institutional interactions. It is not uncommon for bar associations to organize events such as seminars, lecture, farewell functions, on the retirement of judges, gatherings on festivals or occasions like New Year, where members of the bar and the bench interact with each other. Even friendly matches, including so and so, are played between the bar and the bench. This court is of the firm opinion that no litigant can be permitted to sever or weaken the relationship between the bar and the bench, which is sacred and stands above the politics of any level. The bar and the bench share a relationship which may perhaps be beyond the understanding of many, but the bar and the bench themselves understand it in the manner in which it has been understood historically. Furthermore, some members of the bar may at times be representing a particular party. However, when they appear before a court of law, whether in private matter or otherwise, their cases are adjudicated on the basis of the merits of the case and not judging them through the prism of ideology or political affiliations. Many persons are appointed to the bench from the bar, and they may have different ideologies and may have represented a different government. However, it does not foreclose their mind to impartial judging. The judiciary cannot be placed in an ivory tower and expected to live a life of complete seclusion, cut off from society, organization, and even the bar. If that were so, how would judges understand the society in which people live and the realities of life they are called upon to adjudicate? The floodgates of courts cannot be opened for litigants to plant seeds of distrust, suspicion, and mistrust solely on this basis. Such acceptance would also lead to judges avoiding and declining intellectual engagements and social events organized by bar and attended by the bench, or organized by the bench and attended by the bar. Judges, by this standard, would be forced to withdraw from public discourse and from sharing their experiences. Can a judge attending a legal event and interacting with legal fraternity in, say, a women empowerment program, where only speech is delivered on women empowerment or new laws, be treated as evidence of bias? If such participation is used against a judge by going through social media active archives despite not having attended such events oneself and seeks recusal without specifically pointing out any ideological or political statement made by the judge at such event, judges will eventually stop contributing meaningfully to the legal community. Impartiality is a presumption in favor of a judge, just as integrity is presumed in favor of every constitutional functionary upon taking oath of office. Impartiality is not a legal requirement but an ethical one. When a judge takes oath of office, there arises a presumption that she will discharge her duties fairly without fear of favor. When a person seeks recusal of a judge, that presumption of impartiality has to be rebutted by the litigant raising such a plea. Mere apprehension or personal perception is not enough. The real test of absence of bias is whether, despite personal experiences, professional association, past positions, the judge is able to approach the case with an open mind. Earlier orders passed by this court which were set aside by the Supreme Court. Shri Arvind Kejriwal has also stated another argument was that all the orders that I have passed, यानी मैं जितने भी ऑर्डर करती हूँ इनके खिलाफ, वो सारे ऑर्डर सुप्रीम कोर्ट उल्टे कर देती है। तो मैं जितने भी ऑर्डर करती हूँ उनमें ऑब्जर्वेशंस ऐसी होती हैं कि जब सुप्रीम कोर्ट उन्हें सेट असाइड कर देती है तो इसलिए मुझे ये सुनना ही नहीं चाहिए। उसका जवाब, another submission made before this court was that the earlier detailed judgments passed by this court relating to challenges to arrest or applications for bail, as noted above, were subsequently overruled by the Honorable Supreme Court. In this regard, it is to be noted that the bail application of Shri Sanjay Singh MLA PMLA case was rejected by this court by judgment dated 7 February 2024, who is not even an accused before this court in this case. But I am still giving an example because this example was cited by the litigant himself, who is not a respondent before this court. In the present proceedings, he was granted bail by the Honorable Supreme Court on the basis of concession made by ED that he may be enlarged on bail, and the Honorable Supreme Court had specifically recorded in the order 2nd of April 2024, no comments were made on the merits of the case of Shri Sanjay Singh. Similarly, in the case of Shri Manish Sisodia, the Honorable Supreme Court granted bail to him on the ground of delay of trial, with by judgment dated 9 August 2024. No observations were made by the Honorable Supreme Court on the merits of the case or on the findings recorded by this court while deciding this bail application on 21/5/24. It is also relevant to note that at an earlier stage, the Honorable Supreme Court itself had rejected the bail application of respondent number 8 on merits after considering the allegations and the material placed against him, Shri Manish Sisodia versus CBI. As far as applicant Shri Arvind Kejriwal is concerned, it is pertinent to note that when he had challenged the judgment of this court, upholding the validity of his arrest, the Honorable Supreme Court had found that there were, in fact, sufficient reasons to believe for the purpose of effecting his arrest under the provisions of PMLA. However, only the issue regarding the need for necessity of arrest and whether such necessity is to be read into the power of arrest was referred by the Honorable Supreme Court to a larger bench for consideration, and this court's order was not set aside. Since the said issue was referred to a larger bench and its adjudication was likely to take some time, the Honorable Supreme Court had granted interim bail to Shri Arvind Kejriwal, who had earlier been released on interim bail. When a judge sits as a neutral adjudicator, the parties appearing before the court cannot question the competence of the judge by stating that since some of our judgments have been modified or set aside by a higher court, she is therefore not fit to do justice. यानी अगर किसी कोर्ट का कोई भी फैसला कोई हायर कोर्ट सेट असाइड कर सकती है, तो किसी भी लिटिगेंट को ये कोई हक नहीं है कि वो यहाँ खड़ा होकर ये बोले कि ये जज कोई फैसला करने के लायक नहीं है, क्योंकि जज की कॉम्पिटेंस को उसका हायर कोर्ट डिसाइड करता है, लिटिगेंट डिसाइड नहीं करता. There exists a clear boundary line for judges when it comes to entering the domain of parliament or the state legislature and questioning certain aspects, except as permitted under the constitution. The same principle will apply in reverse. A politician or an accused who happens to be a politician cannot be permitted to cross the boundary and sit in judgment over the competence of a judge. In any case, the fact that judgment has not been set aside or modified is a matter of record.